Dennis O'Rourke.
Mr Speaker, I'd like to begin by acknowledging Ruth Dyson's superb speech on this bill. It was given actually in two parts. First, at the last time that the bill was discussed a few days ago, actually, and secondly, tonight. And her review of this fascinating bill was so comprehensive that it does mean that I will now be able to make a much shorter speech than I otherwise would have. So I want to acknowledge her superb contribution, and it's true. On the previous occasion, I did try to elbow my way in front of her, but I'm glad that I didn't, because now, as I've said, I can make a shorter speech, and that will be perfectly fine, having regard to the comprehensive nature of her contribution. But, Mr Speaker, I do want to say that New Zealand First will support the bill and the recommendations of the Government Administration Committee. And the committee has in fact done a really good job in scrutinising this very large bill, which makes amendments to over 30 Acts of Parliament. Not the sort of thing you'd like to take to bed and read, but nevertheless an important bill in its own right. I do think that the committee has done very well, and the only comments I want to make tonight are in relation to some of the recommendations that the Government Administration Committee has made. And I'm glad to see actually that the first recommendation concerned the removal of clauses 49(1) and 51 of the Local Government Official Information and Meetings Act 1987 and clauses 70 and 71 of the Official Information Act 1982. Those amendments were not appropriate for inclusion in a statutes amendment bill, and it's good to see that in fact that's not being proceeded with. And one amendment concerned a definition of legal professional privilege from the Evidence Act 2006. And that could be interpreted to restrict legal professional privilege only to circumstances where proceedings were in train or contemplated. And that wasn't the intention of this particular piece of legislation either, so it's good to see that's gone. Another would amend the grounds for providing a good reason for withholding legal professional privilege, and those again are not suitable amendments for a statutes amendment bill. So I don't know how those ones all got into this this piece of legislation in the first place. They shouldn't have been there, and the committee is right to recommend their exclusion or amendment. But, Mr Speaker, there is one important area that I do want to comment on, and that does concern official information requests. Now, these are very important to a large number of members of the public, and I'd have to say that far too many requests for official information are not properly dealt with by the agencies or the local authorities that deal with them. And this is an area which probably needs a lot more attention than it's getting here, but some sensible amendments are being made which we can support. Now, the amendments to the Local Government Official Information and Meetings Act and the Official Information Act would allow official applications for official information to be made orally. And it is important that that be possible for people who are not used to dealing with written requests and formalities of that kind. And there are plenty of people in that position. So it's very important that those people should be comfortable in being able to make oral applications for official information, and they should be able to get it on that basis. The tension, of course, is that if people make oral applications, they may not be as clear or comprehensive as perhaps they should be if they were done formally in writing. So there's a bit of a tension there between the need for people to have that right to make oral applications and for them to be clear enough to be acted upon by the agency or the local authority concerned. However, it is open to abuse by such agencies and local authorities to be obstructive if they can say, well, you have to put this in writing, oral isn't good enough, it isn't clear enough, So there's a bit of a risk there. Now, the committee amendment's very sensible because what it says is that they can make such a request conditional, allowing the request only if the local authority is able to properly say that it is reasonably necessary for the purpose of clarifying the request that it be then made in writing. So I think that's a pretty satisfactory balance between that tension I spoke of, between the right of an applicant to be able to make an oral application and the need for it to be clear enough to be acted upon. And so if it's necessary, and it's a condition, if it's necessary, then the local authority or agency can then say, in these circumstances, you need to make a written request. I think there's a pretty good balance being reached there, and New Zealand First can support those amendments for that reason. But it is an important area of the law, and we shouldn't underestimate the importance of official information requests to members of the public, because they need to have good access to information, and far too many local authorities and some agencies do make it far too difficult. They are more likely to be obstructive than helpful, and that's not good enough. As I've said, this is an area I think that does need further looking into and change in the future. But as far as these changes are concerned, New Zealand First can support them as part of a Statutes Amendment Bill. Now finally, Mr Speaker, the only other comment I wanted to make does relate to the minor amendments to the Local Electoral Act and the Local Government Act 2002. They are only technical in content, and it appears that they were unintentionally omitted. They relate to the time frame for completing pre-election processes for general elections, and the sensible change is that they will now be applied to all elections and polls, not just general elections. Now that's something which in itself isn't a very big matter, but one of the things I've noticed in some of the legislation we've been dealing with over the last few years is that there is not a very good comparison between local government elections legislation and general elections legislation. There's no reason for the differences between that legislation, and a bit more work does need to be done like this to making sure that they both operate in the same sort of way. It's just not sensible that local elections and general elections should have different rules. I think it's pretty sensible that we have consistency. So I'm glad to see at least we're making a little bit of progress. With this amendment, we need to do a lot more for them. Mr Speaker, all of the changes otherwise, other than those I've mentioned in this very large bill, are very sensible, so New Zealand First will have the greatest pleasure in supporting it at this stage and further.